Mark Levine, Bradshaw Management Group. I thought I would discuss with you something that's going to hit a lot of co-op boards right in the gut. So we all know that the co-op application process for purchasing an apartment is a pretty thorough one. And I know that in my firm, we have almost 50 buildings and we have almost 50 applications, most of which are co-ops because that's just the way that New York City is split between co-ops and condos that we manage anyway. So I wanted to talk to everybody that may be affected by this as to the interview process and specifically if a board could deny somebody based on a purchase price. So I figured that first let's run through just discrimination, what you are not allowed to base your decision on, and that will be a good starting point for our purchase price discussion. So just to get it out in the open, so discrimination is prohibited in board admission procedures. Now, I'm taking this from the Real Estate Board of New York, and it lists the protected categories. So if you're interviewing a prospective candidate and you are looking at these things that I'm about to outline in the decision-making process of whether or not to proceed with the application and approve it for transfer, stop right now. Let's listen to these and we'll get through to the next step. So you're not, the protected categories are age, alien status, children or childless state, country of national origin, creed, disability, gender, including gender identity, lawful occupation, marital status, military status, partnership status, race, religion, and sexual orientation. So right off the bat, these are all protected classes. They're not to play into your decision-making whatsoever. The thing that can come into play is financial. So if somebody is not able to afford, based on either their current bank account holdings or their monthly income, their yearly income, maybe they have a job that is primarily tip-based and they can't show a steady income, that's one thing. The other thing is purchase price. As a board, can a board set a floor and say, well, we're not going to allow any sale under X dollars? I've actually run into this in a few co-ops, and we've dealt with this one by one as we go. And there is a solution to this, and basically any perceived value by the board really has to meet market value and what is out there in the market today. So what you could do as a board, and I'm talking about this from the board's perspective, if what you could do as a board is sit down, go through the apartment itself. If you don't feel like the purchase price is meeting the actual value that's marketable at this point, what the board could do is hire an independent appraiser to act on behalf of the board to actually do an assessment, do an appraisal of the actual value in their opinion, based on the external market factors and based on comps in the building and comps in the area. Now we know that comps in the area aren't always going to hold up because each building is significant in itself. Some buildings may have 5 elevators and some may not have any, but there's a expectation that the appraiser will actually weigh out those factors. So if you're armed to the teeth with financial information showing that an independent study has shown that, let's say it's a $200,000 apartment and the appraisal came in at $250,000, the board could use that as leverage to say, look, we're showing that this is, showing a $250,000 on our appraisal. You're at $200,000. We can't approve the sale based on this, and you could give them the option of either walking away from the contract without approval from the board, or what you could do is say, it really depends on the board. Also, some boards will say, okay, we'll meet in the middle and we'll be happy. This way, we don't destroy the comps in the building. Or you could push it as close to that, let's say, $250,000 number as you can. So the board does have some leverage. It could go the other way. I've seen appraisals. Let's give the $200,000 example again. Contract comes in at $200,000. The board thinks it's $230,000. It actually appraises at $170,000. So you're kind of shooting yourself in the foot on the other end of the equation, because if you show that it's $170,000 and you have a $200,000 sale, you should approve it. Otherwise, it could get quite messy. So that's just one example. In the future, we'll be handling all sorts of issues that deal with co-ops and also condominiums. We'll touch on right of first refusal as well. Keep a lookout for those videos in the future. If you want to find us on Facebook, you can see us at facebook.com/XLBradshaw. On Twitter, we are at XLBradshaw. You can always email me. I love hearing from you guys, and I'm happy to put some of your ideas and some of your questions in these videos to help get information to the masses. My email is mblevine@ebmg.com, and my corporate website is ebmg.com. Again, Mark Levine from XL Bradshaw. I hope to see you again. Till next time.